You're gonna be under arrest.
For what?
For not listening to me.
I think the emergency is the video, somebody's videotaping.
Okay. And the shirt says, I believe, balls deep. He says his name is Captain Awesome.
Hey guys, Rogue Nation here with you today, and we're going to be going over just two cases today. These are recent cases out of the First Circuit Court of Appeals. The first one that we're going to look at here is Burge versus School Committee of Gloucester. It's First Circuit. I believe it was decided in July. So we'll go through just a little bit of the case. I'll leave links for the cases below so everybody can read them in their entirety. Again, this is First Circuit. This is only, I don't want to say applicable in the First Circuit, but it's only precedent in the First Circuit. So it would only be persuasive or secondary authority in the other circuits. But the reasoning that these guys use to decide these cases is pretty much applicable everywhere, right? So let's get into the case. The first one is a case of citizen journalist recorded video in the superintendent's office. So we're going to get into the case here. I've already looked the case over. We're going to start on page 22. It's 28-page decision here. We're going to start on page 26 here. Actually, it's 22. Sorry, I don't know how I got to 20. Because what we're going to get into here is a right to publish. It's actually on page 19 there, guys. That we're going to get started. Sorry about the confusion here. But it says Burge very publicly recorded public officials performing public duties in the publicly accessible part of a public building. All to get information about the district's COVID-19 policies in a forum he could then share with the goal, to quote again from the complaint, of exposing and commenting on the unreasonableness of these policies. See Citizens United versus FEC, remarking that the right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to an enlightened self-government and a necessary means to protect it. And his speech, front and center in the complaint about COVID-19 protocols, the kind that has sparked much political and social debate and litigation too, strikes us as sufficiently a subject of legitimate news interest to come within the sphere of public concern. If the First Amendment means anything in a situation like this, it is that public officials cannot, as they did here, threaten a person with legal action under an obviously inapt statute simply because he published speech they did not like. Okay, and so basically what this case is about is this gentleman, he went to his public school board. He was making videos, of his interactions with the public officials there. They all, and this is, point by point, exactly what happens in a First Amendment audit. He was in there, he was openly recording. The people in the office told him, hey, we don't want to be recorded, we don't give you our consent, yada yada yada. And then when he went home and published it, no one's not an auditor, let me say that right away. When he went home, he published his video to Facebook, and then the school district human resource director reached out with an email and told him that if he didn't remove the video, that he could be facing legal consequences under the wiretapping statute. Instead of removing the video, he went ahead and sued the school board like a boss. And he won or he hasn't won, it was remanded. This is remanding it back to the court, but his claim that he has a right to publish was upheld. So it says, reminding that the First Amendment generally bans government officials from subjecting an individual to retaliatory actions for engaging in protected speech. So basically, when these guys file privacy complaints on our videos, not private citizens, but public officials, when public officials hit us with privacy strikes, that's exactly what they're doing. They're retaliating against our speech because they don't like the fact that they were seen acting a fool, and they don't want that information to get out to the public. So this is definitely a great case for the right to publish and what's known as subsequent punishment, where they'll try to remove your publication after it's been published because they don't want the public to see it. It says retaliation is always reprehensible, and that is obviously improper for officers to invoke legal processes for retaliatory purposes. Let's see what else we got here. What is more, and is already explained, the letter cited the State Wiretap Act as the only basis for the removal demand. No one defends the threat on any other ground. But as also earlier noted, the Wiretap Act only bans secret recordings, in which the persons recorded did not know they were being recorded, and thus does not apply here, which shows the complaint plausibly alleges that the individual defendants knew such action was baseless. And none of the individual defendants' comebacks compels a different conclusion. For starters, the individual defendants write that if, as Berg seems to insist, a First Amendment right to record his visit is a prerequisite to Berg's First Amendment claim for a right to publish, then the judge correctly dismissed the retaliation count because Berg had no First Amendment right to record, emphasis added. In other words, at least according to the individual defendants, which of course are the public officials, without a viable First Amendment right to record, Berg's Facebook posting enjoys no First Amendment protection. But as Berg's appellate papers point out, there is a right to publish case, without a distinct claim over a right to record. And as Berg's counsel indicated at oral arguments, we need not, given the case's posture, decide whether Berg has a First Amendment right to record. So they didn't even decide whether he had a right to record in this case. It wasn't brought up. It wasn't an issue. What is issue at this case is the right to publish. All right, and it's really interesting what the court has to say here. So we're gonna keep going. So even if Berg had no First Amendment right to record, and we express no opinion either way, that would not mean, given the complaint's facts, that the individual defendants could then baselessly burden his First Amendment right to publish. On the right to publish issue, the individual defendants contend that because Berg wanted tickets to his daughter's play, his visit focused on his concerns rather than the public's. Meaning, the argument continues, his speech fell outside the scope of the First Amendment. But some topics can both affect a party's personal interest and concern public affairs. Yet still, just like Berg's COVID-19 related speech, land on the protected side of the line. From this, we hold that Berg's speech involved a matter of public concern. Shifting then from qualified immunity step 1 to step 2, we also think it follows naturally from the above cases that Berg has plausibly pled a violation of a clearly established right to publish on a topic of public interest when the violators acted And by acted, we mean, as the complaint alleges, threatening Burge with an obviously groundless action. Surely no sensible official reading these long-on-the-books opinions could believe that that act, assuming it represents an adverse action, was not a burden on Burge's First Amendment right to publish on a matter of public concern. So given all this, Burge's complaint plausibly alleges that the threat constituted First Amendment retaliation in violation of his clearly established rights. And the individual defendant's pushback does not go far. Convinced that Burge failed to meet his burden of showing a violation of any clearly established First Amendment right to publish his recording, the individual defendants, sort of echoing the district judge, fault him for not citing a case showing that he could record and publish non-law enforcement personnel, such as school administrators, performing official duties in a limited or non-public forum where reasonably viewpoint-neutral restrictions on speech are routinely permitted. But a directly on-point case is not required. We say that because the general constitutional rules highlighted above, including, for example, that the First Amendment prohibits government officials from subjecting an individual to retaliatory actions for speaking out, are so clear that even without a pre-existing case involving the same facts, and still assuming the threatened legal action would construe an adverse action, the unlawfulness of what occurred is apparent. In addition to repeating an already rejected argument that the complaint's facts put Burge's speech on the purely personal rather than public concern side of the constitutional divide, the individual defendants lean on PETA v. Medorus, and that's the second case that we got up here, and we're going to look at that in a minute. It says, but PETA did not involve alleged retaliation against the plaintiff's right to publish, but instead supposed retaliation against his right to record. So that case has no bearing on our analysis. All to say, we cannot now hold the individual defense qualified immunity on the retaliation count and so vacate the judge's dismissal of count 1 against them. Now, his declaratory claims were dismissed, but that's because the school revoked the letter that they sent him about going forward with legal action against him, and the school also promised that this kind of activity wouldn't happen again, right? So there's no reason for the court to make a declaratory judgment and tell the school not to do that, because the school already agreed not to do that. So those counts were dismissed. But the first count with his right to publish was remanded. So what was noticed in this case was, and what was said in this case was that even if the recording was illegal, he still had a right to publish the video, right? Even if the making of the video was illegal, if the recording of the video was illegal, he still had a right to publish the video, right? Now, this case doesn't get into the right to record. The PETA one does. We're going to go to that one right now, but the PETA case is a little bit different than a First Amendment audit type case. In this case, Mr. Scott was at the regional school district for Bridgewater, Rainham, wherever that is, obviously in the First Circuit somewhere. And he claimed that he had a First Amendment right to video record a private meeting discussing his child's individualized education program. And of course, the court obviously found that he did not have a right to record this private meeting. One, because it's private. The court also noted that Pratt's claim right to record was not linked to the public's right to receive information. Finally, the court reasoned that even if there was a First Amendment right to record such meetings, the school district's prohibition of video recording served a significant governmental interest and was narrowly tailored. And I absolutely agree with him. This is an IEP meeting. It involves sensitive information about a child and their program, their schooling, I guess you could say platform or schooling program, you know, how they're going to go forward in conducting the schooling of said child. It's not held in a public place. It's a private meeting, even though it's on Zoom. It seemed here, it was a private meeting. But let's go down here. Hold on, let me pause this and we'll get to the interesting point. Okay, now here we are on page 10, it looks like. And it says here, it was unclear whether a right to record public officials existed without a corresponding intent to disseminate the recording, which it found PETA did not allege. All right, so one of the reasons that Mr. PETA lost the case, besides the fact that it was a private meeting and he had no right to record a private meeting, was the fact that PETA did not allege that he intended to disseminate the recording. There's a right to record public officials, but it's not for your scrapbook, right? The right to record public officials exists with a corresponding intent to disseminate the recording. That's the right to free press. The right to free press isn't to make scrapbooks for yourself. The right to free press is to gather information and disseminate it to the public, right? So there's the two parts there. Gather the information and then disseminate the information. That's the right to free press. So let's continue on with this one. Now here's the most, I think, important part of this case here, guys. So definitely this will be something that you want to check out here. But on the bottom of page 19, it's talking about public spaces, right? And conjecture and together with their case law in the First Circuit about recording public officials in public spaces, right? So what are those public spaces, right? Now the trolls would like us to believe that we can only film from traditional public forum, right? Which is sidewalks, parks, places like that, right? And that because if a building is a limited public forum or non-public forum, that we're not allowed to videotape inside the building, right? Well, this is going to smash their hopes and dreams right here, all right? So in Project Veritas, we noted that our cases have fleshed out the contours of the public space category. Traditional public fora, such as the public parks like the Boston Common, which was the site of the recording in Glick, the sites of traffic stops, including those that occur on the sides of roads, see Garrick, and other inescapably public spaces, such as the location of the recording that occurred in Iacobucci versus Bolter, which concerned a journalist's arrest for openly recording members of the Pembroke Historic District Commission that were having a conversation in the hallway of the town hall immediately following an open public meeting. So what the First Circuit is saying there is that the hallway of the town hall is inescapably a public space. Inescapably. And they say that because anywhere that the public is allowed to go where there's no expectation of privacy is inescapably a public space. Even the hallway of a limited public forum town hall. Okay, when it comes to recording, okay, it's not restricted by the public forum doctrine. It's restricted by the right to gather information, right? The public's allowed to go into these places to gather information. The press is allowed to go into these places and gather information. And we know this to be true because of the case Pell, okay? Now, Pell was a case about the media wanting access to prisoners in prison, right? They wanted to go into the prison where the general public wasn't allowed to view the conditions. They wanted to go into the prison where the general public wasn't allowed and conduct interviews. And the court told them, no, you're not allowed to do that. You're only allowed where the general public is allowed, right? They said, look, these prisons give tours for the public. You're allowed to go on these tours, right? The court didn't say, well, you know, the general public can do tours in the prison, but because it's a limited public forum, you can't gather information on the tour, right? They didn't say that, okay? Wherever the public is allowed to gather information, the press is allowed to gather information. Say in the hallway of a town hall, like the First Circuit just clarified for us, right? So I'm going to leave the links for both these cases in the description. Definitely great cases to look over and read, especially if you're an auditor. I want you guys to comment down below with any questions, comments, or concerns you have about this video or this information. Any clarity that I've seemed to have missed is also always appreciated. So let me know what you guys think, and we'll catch you guys on the next one. All right? Thanks for watching, guys.